Hello, I'm Liz Grumbach, Assistant Director of the Institute for Humanities Research. Welcome. We're here today to celebrate the IHR's Book Award Honorable Mention. Every year, the IHR recognizes outstanding humanities-based scholarship that is interdisciplinary in nature, public-facing, and has immediate relevance and impact on our current challenges. The books awarded exemplify how the humanities can speak about the past, speak to our present moment, and how the study of the humanities can help us imagine new futures. This year, our review board selected a book award winner and an honorable mention from over 50 nominations submitted from over 45 publishers. Today, we're here to celebrate our honorable mention, Dr. Francine Banner's Crowdsourcing the Law, Trying Sexual Assault on Social Media. Before we begin the lecture, however, I have a few housekeeping things. Thank you to our behind-the-scenes moderators today, Lauren Whitby, IHR Communications Specialist Senior, and Selena Asuna, IHR Coordinator. This event wouldn't be possible, no event would be possible at the IHR without them. I'd also like to thank Joseph Carter of Live Stream Success, who is running our streams today. You may have noticed that chat has been disabled on Zoom. Please ask a question for our speaker at any time, as early as possible, by using the Q&A function on the bottom of the Zoom window or by commenting directly on YouTube in the chat, should you be watching on YouTube. And our moderators will relay that to our hosts today. And now it's actually a pleasure to welcome Dr. Gray Cavender, who will be introducing Dr. Banner today. Welcome to the IHR, Gray, virtual IHR. Dr. Cavender is an emeritus professor of justice and social inquiry in the School of Social Transformation here at ASU. His research centers around media, crime and punishment, and law and society. Gray, I'll hand the mic over to you. Thank you for being here, and I cannot wait for the lecture today, Dr. Banner.
Hi, everybody. I wanted to make a few introductory comments this afternoon about Dr. Francine Banner. Her academic background includes a degree in English from Wellesley College, a law degree from NYU Law School, by the way, she has indeed practiced law, and a Ph.D. in justice studies. Obviously, she has an interdisciplinary background and her work reflects it. She's an associate professor of sociology and an affiliated faculty in women and gender studies at the University of Michigan, Dearborn. She's conducted research in several areas, including gendered violence and also social media. In terms of gendered violence, she's studied sexual assault and harassment in institutional contexts, like in the military. In terms of social media, I wanted to specifically recommend an article of Dr. Banner's, Methodological Approaches to Studying Crime and Popular Culture in New Media. We increasingly have students who use some aspect of social media in their research, and Dr. Banner's article is an excellent piece for generating a cross-disciplinary awareness about how to do such research, and also in terms of understanding the implications and limitations of such research. And notwithstanding the title, its importance is not limited to studying crime. But we're here today to celebrate Dr. Banner's most excellent book, Crowdsourcing the Law, Trying Sexual Assault on Social Media. I nominated it for the IHR Award, first because it's just a fine book, but second, I thought it promoted a humanities sensibility in terms of understanding conversations on the media about sexual assault and rape. Obviously, it's a timely book. It coincided with the Me Too movement, but it also offers an understanding for how social media have played such a significant role in publicizing cases that in the past have too often received little media attention or legal attention. Bottom line, Crowdsourcing the Law is an agenda-setting book, and I'm glad it's being recognized today. So let's turn now to Dr. Francine Banner for her comments.
Thank you. Thanks so much, Gray, to my friend and mentor for that wonderful introduction and for nominating the book for this award. I'd like to also extend a warm thank you to the Institute for Humanities Research for hosting me today and to everyone on Zoom for joining. Before I begin, I'd like to acknowledge any survivors who are present, and I want to say if anyone needs to click off a Zoom or take space for any reason, please do so. the topic of sexual assault, not to mention talking about race, gender, politics, is tough in the best of times and is particularly tough right now at this political moment. I know it can be difficult to transition in general, and in particular to these somewhat artificial moments on Zoom. So I'd like to mark our movement into an intellectual space today by reading a poem that's been on my mind as I prepared these remarks. This is by Langston Hughes. That justice is a blind goddess is a thing to which we black are wise. Her bandage hides two festering sores that once perhaps were eyes. As we enter the space for this talk today, I'd like to ask that we bring to mind this typical physical manifestation of justice, often portrayed as a blindfolded female figure in flowing robes, holding a scale upwards in her left hand and a sword in her right. This iconic representation of Lady Justice, who we see in Hughes's poem and in courthouses across the globe, has been on my mind at this time when we're focusing so much on dismantling and reinventing monuments. Just last week, the Mellon Foundation earmarked $250 million for applicants to reimagine these physical symbols so that rather than reproducing dominant narratives, they question what we accept as common sense and how common sense ideas shape our understanding of the history and the present. As I prepared this talk, I found myself thinking a lot about this common physical manifestation of justice, the lady with the balance scale and the sword, and how we might deconstruct and reimagine this concept were we asked to do so today. More significantly, I've been mulling over the idea of deconstruction in the literary sense, searching for the meaning of a thing to expose the contradictions and internal oppositions on which that thing is founded. Deconstruction is a way to demonstrate that the very foundations of something are irreducibly complex, unstable, or impossible. Today, I'd like to engage just some examples from my book to explore some of the ways that sexual assault law is irreducibly complex at its core, and to recognize these tensions in the law so that we can start a discussion of how justice might be reshaped, to explore where foundations may be unstable, and to think about repairing or unseating those foundations. Sexual assault law is clearly in need of deconstruction. While there are many aspects of law that are complex or discriminatory, I'd argue that sexual assault law has more unstable and impossible foundations than most. It's the only branch of law where these biases are so pervasive they have a name, the rape myth. Most of us now are probably aware of rape myths, the stereotypical and insidious beliefs that shape both the Black letter law and public opinion about events, victims, and perpetrators. Some, like victim blaming, function as self-preservation, creating an artificial distance between a survivor and the general public by promoting the idea that survivors are somehow personally responsible for an assault based on what they wore or where they went, or that a typical rape occurs when a stranger leaps out of the bushes. The operation of these ideas, which the law not so long ago accepted as common sense truths, means that rape law historically has functioned to exclude countless deserving victims and to unjustly punish numerous defendants, particularly defendants of color. What is the most prominent place where myths are disseminated, reinforced, or challenged today? I would argue that that's on social media. I'd like to enter into the discussion today by giving a brief description of the book for those who have not read it. And then for the remainder of our time, I'd like to focus more closely on the ways in which people discuss changing legal norms and ideas on social media platforms. In the book, I chose to focus on high-profile cases, Turner, Cosby, Weinstein, Brett Kavanaugh, and others, exploring how, as we discuss them, celebrity bodies become sites onto which society's desires and anxieties are projected, a focus for discussion of issues that are sometimes outside polite debate. I discuss celebrities because they're bigger than us. When sexual assault allegations are brought against well-known individuals, or when individuals unwillingly become household names after allegations, it gives us, the public, a unique opportunity to talk about things we may not have the words or ability to discuss with coworkers and neighbors. Debates that a few years ago might have taken place in real life have been relocated online. Commenters eager to share their opinions on guilt or innocence with legions of virtual strangers. On social media, deconstruction is happening in its literary sense. Searching for the meaning of a thing to expose its contradictions, the internal oppositions on which that thing is founded. Today, using one example from the book, that of the Cosby trial, I'd like to focus on what I see as places of contestation and negotiation at our present political moment. I want to focus on two areas. One, what does it mean to believe women? And two, what does due process look like? Tying these questions back to the overall theme, how can exploring conversations on social media help us to begin rethinking and reimagining what justice looks like going forward? To get the conversation started, I'd like to take us in the Wayback Machine to what was a kinder, gentler time, the year 2017. It was not really kind or gentle. 2017, you might recall, as a year that, although not the dumpster fire of 2020, certainly provided its own anxieties. 2017 was the year of the hugely attended inauguration of President Trump, a year in which thousands of women and allies first marched in pink hats to protest the president's behavior and policies. Hurricanes Harvey, Irma, and Maria devastated the southern US coast. The US withdrew from the Paris Agreement on climate change, and the president fired FBI Director James Comey, leading to the appointment of Special Counsel Robert Mueller to lead something called a Russia probe. Summer 2017 also was a time when the public turned their attention to comedian Bill Cosby as he was tried for the sexual assault of Andrea Constand. To refresh the facts, Cosby met Constand in 2002 in the context of her job as Director of Operations for Temple University, where he was a significant donor. Cosby described what he called a mentoring relationship with a 30-year-old professional. He reported frequently inviting her to his home, where they would discuss her life and education. In 2004, during one of these visits to Cosby's home, Constand complained of a headache. In response, Cosby gave her some blue pills. She reported that she took the pills and then faded in and out of consciousness, waking with her sweater bunched around her and her bra undone. Constand said she'd been assaulted. Cosby claimed the encounter was consensual. Constand reported the incident to the police, but the state declined to prosecute. She then joined several other plaintiffs in a civil suit that ultimately settled in the millions. Legally speaking, it seemed like the end of the road. Then, 8 years later, comedian Hannibal Buress called Bill Cosby a rapist during a stand-up routine. His comments opened the floodgates. More than 60 women came forward, publicly voicing narratives that were strikingly similar to Andrea Constand's. In 2015, the investigation into Constand's allegations was reopened. By 2017, the state determined there was probable cause to proceed with a criminal trial. In the shadow of a highly contentious presidential election, the trial seemed to be a litmus test for America's tolerance for sexual misconduct. Of more than 60 accusations against the actor, Constand's was the only one to see the inside of a criminal courtroom. The trial resulted in a hung jury. During that first trial, a key procedural argument concerned whether accusers besides Constand should be permitted to testify. The state wanted to introduce testimony from other accusers to show that Cosby had a quote-unquote signature, a unique pattern of behavior that involved using fame to secure women's trust, then incapacitating and assaulting them. The defense countered this idea, using fame to manipulate victims, arguing that this was not a calling card, but a cliche. The state was describing behavior so common, the defense argued, that even if Bill Cosby had done all of these things, they were not unique enough to be a signature. Cosby's attorney elaborated in his closing statement, "How many men and women have been willing to offer up their bodies on the casting couch, have been willing to exchange sex for favors, have had remorse after doing so, and then accused someone who they believed they could get monetary gain out of to sell a story." In any criminal trial, the overarching evidentiary rule is that the probative value of any piece of evidence must outweigh its potential negative impact on a defendant. And in 2017, the judge excluded testimony by other accusers, accepting the defense's arguments that on balance, the banality, the regularity of coercive sexual encounters between powerful older men and young women weighed against their tendency to indicate serial predation. In other words, the casting couch was so common, what took place there could not be evidence against the accused. Think about it. Just 3 years ago, the sheer number of accusers was spun into an argument in favor of the defense. While the state argued that a flood of multiple accusations should reinforce the celebrity's guilt, Cosby's attorneys argued that a spate of women coming forward merely suggested Cosby's status as a wealthy target. Defense attorneys accused fellow lawyer Gloria Allred of parading accusers in the media, warning of a predatory barrage of new accusers claiming "Me Too." The defense's argument took only 6 minutes, largely focusing on the accuser's thirst for media coverage, and the strategy was successful in convincing 2 jurors to find reasonable doubt. Then the world shifted. In fall 2017, in response to emerging multiple accusations against producer Harvey Weinstein, actor Alyssa Milano tweeted "Me Too." In the course of a day, the hashtag status, borrowed from activist Tarana Burke, was retweeted and posted on Facebook 12 million times. When the state retried Cosby in the spring of 2018, just 11 months after the actor's first acquittal, this time they tried a different strategy. They argued that the prohibition against introducing prejudicial evidence of prior acts should be overcome by the doctrine of chances, the mathematical probability that had Cosby engaged in bad behaviors with others, he also would have done so with Andrea Constand. For the argument to work, the other accusers' claims didn't have to be proven in court, but they needed to be credible. And this time around, the judge found they were. 5 accusers besides Constand were permitted to testify at the second trial. Cosby was convicted. What changed from the first Cosby trial to the second? Factually, nothing. But for victims and perpetrators of sexual assault, however, 2018 was a different world. During the second trial, the Cosby judge took pains to explain that social movements were to be excluded from the courtroom. He carefully questioned would-be jurors as to whether they had heard of hashtag Me Too, disqualifying those who admitted their knowledge of the movement might impact their ability to remain impartial. Jurors themselves discounted any impact these campaigns may have had on their decision-making, referencing instead legal-sounding criteria, such as evidence and credibility. Bill Cosby, however, was not just convicted in a bricks-and-mortar courtroom. He arrived at the Montgomery County Courthouse, having faced a drawn-out trial in the court of public opinion. His jury comprised of millions, newly obsessed with dry procedural doctrines, such as statutes of limitations, and woke to the power of social media to effect legal change. Of 120 potential jurors in the second trial, only 1 claimed not to have heard something about this new global conversation about gender, power, privilege, and consent. After Cosby was convicted, attorney Gloria Allred proclaimed from the courthouse steps that the outcome meant that women would be believed, not only on hashtag Me Too, but in a court of law. That success of the rather obscure doctrine of chances attests that by 2018, Me Too had taken on a completely different meaning than it had had just a year before. In the first Cosby trial, the pervasive specter of the casting couch weighed in favor of the defense. If so many older male Hollywood power players were pressuring young women for sexual favors, the reasoning went, then such behavior could not be the unique imprimatur of a serial predator. Just a short time later, thanks to the Me Too social movement, the casting couch was starting to look like a strikingly different place. Rather than, as Cosby's attorneys had attested, a place where young men were quote unquote offering their bodies in a business transaction, the casting couch now appeared to be a hunting ground. As a society, we were realizing that what we had taken for granted as boys will be boys, in fact, was a long-standing cover for serial criminal behavior. The Cosby trial highlights that we're living at a conjuncture in which sexual assault laws are being renegotiated, both on the books and importantly in everyday conversation. So returning to the questions I want to ask today and to the book, what are some of these places for tensions and contestation? First, what does it mean to believe women? The Me Too campaign has created a space for persons who have experienced sexual assault and harassment, or perhaps perpetuated sexual assault or harassment, to view what they might have previously dismissed as a minor violation or an isolated event as part of a larger rape culture. This realization of collective shared experience is unprecedented. In January 2016, about 1 million people were talking about sexual harassment on Twitter. In January 2018, almost 8 million people had something to say about the topic. Along with Me Too, a prominent hashtag has been #BelieveWomen. The hashtag is intended to operate as the Black Lives Matter hashtag has, to inspire people to re-examine the social forces that work against the credibility of women accusers, rather than immediately discounting claims. To treat sexual assault victims with the same validity and legitimacy as we treat victims in other criminal cases. However, by many, the hashtag is interpreted as something different. The idea that any woman coming forward with a sexual assault allegation must not be questioned. On social media, this is sometimes accomplished via a small but significant sleight of hand, adding the words all, so that a hashtag reads, "Believe all women." What tensions underlie these debates about the Believe Women hashtag? Exploring social media treatment of Andrea Constand can give us some insights. After the first Cosby mistrial, I reviewed comments about Constand on liberal and conservative media sites. I'll read just a few of the representative statements here, quoting from the social media comments I reviewed. Women need to take better care of themselves. Bars and hotel rooms are not a place for advancing careers and establishing serious relationships. Another, not excusing rapists, but nobody should be stupid. Take care of yourself. Don't make it easy to be victimized. A pretty young girl needs to not make questionable decisions, such as walking down dark alleys or finding yourself alone with older men who want to help. If a beach has signs that say no swimming, sharks in the water, are you at fault for getting eaten? Yes. Sharks are animals. There are people who are animals. If you foolishly give them the opportunity, then yes, it is your own fault. And last, when women go to a married man's home or the Playboy mansion, they know the score. If you choose to go, it implies consent. I want to note that in deconstructing the results of election 2016, researchers often proclaim the existence of a media bubble, the tendency of liberal and conservative voters to seek out like-minded commenters rather than conversing across political borders. The Clinton campaign in particular complained of a Breitbart effect, attributing the candidate's loss largely to conservative voters being pummeled with misogynist rhetoric in siloed environments. One thing I noticed in analyzing comments on the Cosby trials is that when it came to discussions of sexual assault, there in fact was less of a media bubble than I had assumed there would be, and that conversations across liberal and conservative sites tended to employ different language, but the outcomes tended to be strikingly similar. What are some of the challenges and tensions that we can notice in these comments I read earlier? First, we can see a distinctive rhetorical transformation of a situation that's influenced by that powerful myth of the casting couch. Recall that at the time of the assault, Andrea Constand was not a striving young actor, but a business executive. Cosby was not a stranger, but a close friend and mentor whom she had known for several years and met in a professional capacity in the context of her job as director of operations for a major university. The assault took place not in a Hollywood hotel room, but at Cosby's home in Pennsylvania, a place Constand had been many times before in a professional capacity. Yet in online comments about Constand, notably, we rarely get a sense of professional interactions, mentorship, or a work relationship. Rather, across sites, there's a persistent reimagining of the encounter, from a business meeting between colleagues into an encounter between a tipsy and idealistic young girl and a successful celebrity. Cosby's home is sometimes transformed into a hotel room or a bar. These comments not only suggest the powerful trope of the casting couch, they suggest the pervasiveness of the real rape myth, that real sexual assaults only occur between strangers, that they're not committed by our long-term neighbors, teachers, or good friends. In these comments, we also see importantly what Jansen describes as the inverted process of a rape trial, the ways in which both the letter of rape law and its procedural spirit historically have been applied to shift assessment of guilt away from the actions of a perpetrator and on to examining the character of the accuser. A strong trend among comments, not only about Cosby's case, but in other celebrity allegations, is to focus not just on the actions of the perpetrator, but on the behaviors of the accused. In online debates, commenters frequently engage the language of the law. They refer, for example, to facts of the case, observing that Constance went alone, accepted a pill from a stranger, or spent time with a married man, are all evidence of her role in the assault. Yet the evidence that's relied on is often flawed, changing a word or two, changing the perceived character of a situation and of the accuser. Of course, on the internet, accusers are not just discussed as naive or easily manipulated. There's a second thread that we can identify in online comments about Constance that many of you may recognize. This thread of comments does not argue that Constance was naive, but the opposite, that she is a manipulative fame seeker who's attempting to use the legal system to her ends, to capitalize on sexual assault allegations, to achieve money, fame, or notoriety. I'd like to read a few other comments I discuss in the book. I quote, "These women wanted something from Cosby, and they were willing to trade their bodies for it. In Kardashian America, victimhood chic is all the rage. This is feminist rape. She willingly went with him, willingly took drugs, willingly went along with all of it. A year later, she realized he wasn't going to make her a star, so she decided it was rape." And after Cosby's conviction, this comment, "The real business side is starting now. The lawsuits for damages. It's all about the money, guys and gals. Welcome to the real world." Embedded in these comments is a trope we all recognize, the gold digger, the woman who leverages her sexuality for a come up in resources or status. Patricia Hill Collins describes the discursive constructions that we often use to describe women, and particularly women of color, as controlling images. They instantly evoke a stereotype that, I quote, "makes racism, sexism, poverty, and other forms of social injustice appear to be natural, normal, and inevitable parts of life." In a recent study of slut discourse on a college campus, sociologist Elizabeth Armstrong makes a similar argument about female sexuality more generally, observing that terms like slut or hoe often are not used to describe actual sexual behaviors. Rather, among female college student interviewees, the terms were engaged as a way to draw moral boundaries, to segregate groups based on a perceived status. Controlling images are stock in trade on social media, a world that depends on brevity, where there may even be word limits. Engaging recognizable, often raced and gendered tropes like that of the gold digger provides a way for commenters online to quickly classify and order social relationships, as well as to make clear their own political or socioeconomic position vis-a-vis other commenters. The term is not merely derogatory. It functions as an easily recognizable and shorthand way to affirm a speaker's own superior and moral and social standing. As I researched the book, I became intrigued by this particular controlling image of the gold digger and how it gained such resonance on social media. I was interested to learn that our fears about gold diggers are not new. They have a long and complex history. In its very first issue in 1953, Playboy magazine warned its readers to beware of gold diggers who serially married millionaire playboys and then sought divorce. The article warned male readers, "The gold digger is after you." And I was surprised to find the gold digger trope has been around even much longer than that. A prominent example of the uniquely discriminatory, inverted application of rape law is the Hale instruction, which operated in some US courts until the 1990s. The Hale instruction was a specific caution that was given to jurors before they deliberated in sexual assault cases, where the judge would state that a charge of rape was easily made and difficult to disprove. Rape cases were the only type of case to require this instruction, emphasizing that a victim's credibility should be carefully scrutinized and that defendants must be given the utmost benefit of the doubt. The author of the instruction and first to offer it was Sir Matthew Hale, a jurist who reached his prime in the early 15th century. In my research for the book, I learned that Hale presided over trials for both rape and witchcraft, and his opinions were outliers in both contexts. For example, Hale was notorious for having sentenced 2 women to death based on sketchy evidence that the girls had vomited pins, cursed horses, and somehow engineered lice of extraordinary bigness. Accusations that were treated by most jurists with skepticism, even in the mid-1600s. In a time marked by misogyny, Hale also drew attention for his dismissive opinions about marital rape, holding, in contrast to fellow justices, that a husband could never be guilty of rape committed on a lawful wife. Hale's famous and long-standing instruction about the accusation of rape being quote-unquote easily made and hard to disprove was regularly repeated, the instruction that was regularly repeated by judges for 3 centuries, actually originated in a treatise on magic with which the Lord was enamored. The book noted that the accusation of witchcraft was easy to make and hard to disprove. Hale transposed the phrase so that an invocation that most often had been engaged in charges against women accused of witchcraft was now applied to protect men against charges made by women in the context of rape. Hale's sentiments about women were not what one would call unbiased. Married twice, Lord Hale described being tormented by his first wife, with whom he had 10 children. After remarrying, the judge advised his children that an idle or expensive wife is at most times an ill bargain. While the label itself did not yet exist, the foundation for the gold digger was being laid, and its proponents' views on women's truthfulness enshrined in law. Today, the idea of the gold digger is so deeply part of our popular culture, it seems like common sense. What is evidence in the court of public opinion that someone may be a gold digger? For online commenters, one telltale sign is when accusers seek to use the law to their benefit by filing a civil suit. Like most sexual assault allegations against celebrities, a notable feature of the Cosby situation is that many accusers brought civil litigation. Constand herself was part of a $3 million award. In these cases, internet commenters are preoccupied with the question of whether accusers have filed civil suits or accepted settlements, often called quote-unquote hush money, from alleged perpetrators. And for many online commenters, having filed a civil suit is powerful evidence of an accuser's poor moral character. This idea of potentially leveraging sexual assault charges for financial gain, of course, came up in the first Cosby trial, when the defense asked the jury, how many women and men have been willing to exchange sex for favors? It's hard to think of a trial today where this issue of potential financial motivation does not come up. More than 20 years ago, during Mike Tyson's sexual assault trial, witnesses testified that the alleged victim, prior to the assault, had talked about Tyson's money. During his 2005 trial, Michael Jackson's attorney similarly portrayed Jackson's accuser and his mother as motivated by money, criticizing key witnesses for selling their stories to tabloids versus reporting to the police. When Erica Kinsman filed her lawsuit against Jameis Winston, Winston's attorney responded that Kinsman was engaging the law in a game in which she was now 0 for 6 in claims against the player. However, he noted that Kinsman had been successful in one major area. She mounted a false and vicious media campaign with the objective of getting Mr. Winston to pay her and go away. In closing arguments, Harvey Weinstein's attorney similarly reminded jurors that for accusers, there would be a pot of gold at the end of the trial. Today, it is very common for accusers to bring both criminal and civil charges, or criminal charges in to bring a civil case. In recent years, civil lawsuits seeking damages for injuries resulting from sexual assaults have more than doubled. In the past 20 years, opportunities to engage the civil legal system in connection with what before would have been solely criminal cases have radically expanded due to a number of factors: the increased availability of Title VII and Title IX, the passage of the Violence Against Women Act, and ongoing revelations that institutions such as churches or universities have been complicit or responsible in fostering rape culture. The Department of Justice itself advocates that victims of sexual assault, where possible, file a civil suit. These suits are an attractive option for those who have experienced an injury, not only because individual plaintiffs may recover compensatory and punitive damages, but because lower standards of proof and non-unanimous jury requirements make it easier to hold defendants accountable via civil litigation. Despite that, accusers are increasingly likely to use and encouraged to engage in civil litigation. In the minds of internet commenters, justice is an either-or proposition. A typical post about Cosby's accusers inquires, why did they run to the media instead of the emergency room? And another, no one should be able to sue for money when a crime has been committed. If a crime has been committed, the criminal needs to go to jail. Comments referring to victims who file civil suits as gold diggers or presenting evidence that victims have accepted hush money are another way of questioning victims' characters. They also reflect that legal claims today arise in the shadows of tort reform, a political movement that has worked hard to reframe public perceptions of personal injury law, lawyers, and claimants. When we think of that typical image of justice in the context of the gold digger trope, she has clearly discarded the balance and is wielding the sword. The institution of law is recast as fickle, up for grabs, making decisions not based on principle or precedent, but on arbitrary case-by-case factors dependent on a claimant's attractiveness or the shark-like qualities of her attorney. The idea of believe women, meant to counteract the inverted process of the rape trial, is transformed into believe all women. The idea that those historically least powerful under the law now have law on their side and are wielding it for vindictive purposes. This brings me to a related area of contestation today that I will not be able to fully discuss due to the time, but I feel like I at least need to mention, that of due process. To return to Hughes' poem at the start of this presentation, sexual assault law has a long history of bias, of course, not only in regard to victims, but strikingly toward the wrongfully accused. One can't discuss sexual assault law without at least engaging the profound injustice the law has done and continues to do to non-white defendants. To offer just one striking statistic, of the 4,715 executions for rape that occurred between 1822 and 1946, 3/4 of those executed were Black. These represent just the tip of the iceberg in terms of the harm the criminal law has enacted and continues to enact on non-white persons via policies like stop and frisk, chokeholds, or other state violence. As I conducted research for the book, I'd like to say that I was heartened by the extent to which online comments about Cosby's and other cases did engage issues of racial justice and called out the historically discriminatory application of sexual assault law and repeated denials of due process for Black defendants. For example, in discussing charges against Cosby or other non-white celebrities, commenters frequently engage #Emmett Till or refer to the classic novel To Kill a Mockingbird, questioning the prosecution in the context of historically discriminatory prosecutions of other Black defendants. As a commenter on the site of a popular newspaper explains, they're wary of charges against Cosby since, I quote, "This criminal justice system has a very dark history, including extrajudicial killings and racism." Defenders of Cosby not uncommonly refer to charges against the comedian as modern-day lynching. Although these comments don't exhibit an awareness to disservices that law has done to victims, they do begin to identify foundational issues in the criminal law as it regards defendants. Online discussions also suggest some inherent dangers to due process that are posed by social media. Just as there's a race to judgment in terms of accusers, I discuss in the book, when it comes to online condemnation of perpetrators, commenters' demands are that justice be swift and unmerciful, and they often extol the virtues of jailhouse justice. In regard to Bill Cosby, for example, a commenter on a popular news site observes, "I guess he'll be using his fat Albert with his cellmate," while another describes, "One can only hope that a very large and powerful inmate takes a liking to Mr. Cosby. Then he will have an inkling of what these women have endured at his hands." I discuss in the book that comments like these are only amplified in the case of Brock Turner, the Stanford swimmer whose 6-month sentence for sexual assault brought forth a flood of disapproval, not to mention significant changes in law. They're also often directed at lawyers. Those who represent alleged perpetrators or defendants often receive death threats. Just a cursory glance at these comments in the Cosby case suggests that as activists have achieved protections for victims, such as expanding definitions of sexual assault, broadening the range of opportunities for early interventions, they may have paid too little attention to the potential impact the expanded net of laws may have on defendants, particularly non-white defendants. Many online comments also suggest that discussions about perpetrators are also subject to discursive and political reframing that may serve more to obscure than to open dialogue. The term lynching is a prime example. Lynching, of course, carries with it a particular meaning for African American defendants who have been subjected to legal and extralegal terror. However, across common sites, we see the terms lynch mob and lynching not only used to describe sexual assault allegations involving Black, but also white suspects. Many comments compare accusations against Bill Cosby to those against another prominent figure, Donald Trump, noting, for example, that lynching is exactly what the Democrats are trying to do to President Trump. A tweet complains of what seems to be a growing list of allegations against public figures. I quote, "Some tweets out there sound like they want to form a lynch mob. People have the rights to due process, even Harvey Weinstein." Recently, the spokesperson for Alabama Republican senatorial candidate Roy Moore, who lost the 2017 election by a narrow margin when he was haunted by sexual misconduct allegations, described how a quote-unquote lynch mob media was out to attack Republican candidates. More recent accusations against Supreme Court nominee, now Justice Brett Kavanaugh, are characterized similarly. A tweet noting, "Kavanaugh is the one being judged," by a lynch mob. Similar is the related charge that rape allegations are manufactured as part of a feminist witch hunt. President Trump, Woody Allen, Liam Neeson, and other celebrities often use the term witch hunt to describe the contemporary atmosphere surrounding sexual assault. Like Sir Matthew Hale in the 1600s, those in power are turning these ideas of lynch mob or witch hunt on their heads, transforming something used to describe wielding state power against the accused into a defense by allegation of those least powerful. So where does this leave us? As I conclude, I'd like to return to Hughes's poem and ask us once again to bring to mind this image of justice at the start of the talk. In the early 1960s, Supreme Court Justice, then attorney Ruth Bader Ginsburg, identified rape law as having a crippling chivalric protection. She argued that the operation of rape law less signaled respect for women victims' autonomy, but rather the value placed by men on women's chastity. She wrote that the law's effect was to put women not on a pedestal, but in a cage. Ginsburg argued that the sexism and discrimination inherent in the law were systemic problems that amplified one another. I'd like to close by considering Lady Justice in the context of Justice Ginsburg's comments and of conversations on social media today. On social media, deconstruction of the law is happening in its literary sense. The world is discussing concepts like rape culture and victim blaming. It is debating whether conduct does or doesn't fit into a real rape paradigm, whether defendants are being railroaded, or whether a particular sentence that was meted out was just. On the other hand, still there's the power of the crowd. The institution of law exists and is structured to protect those in power, often via a lack of transparency. The controlling images that are deployed on social media too often mask power structures, purposely constructing an imagined world in which control belongs to those least likely to have it. Comments across the internet today reflect a concern that justice is tending more towards the sword than the balance. In typical historical representations, we often forget that justice was not alone. She was always paired with prudence, who is associated with wisdom, insight, and knowledge. In many social media comments, prudence is lacking. Despite calls to equalize punishments among perpetrators, there's a disturbing trend toward a swift and finite condemnation. What can we learn from these conversations that can help us to recognize and perhaps unseat justice's irreducibly complex foundations? That I leave to you, the public, for a discussion that can start here and hopefully continue on social media. Thank you.
Thank you so much, Dr. Banner, for your lecture. I was frantically taking notes, and I think that kind of discussion of this deep rhetorical analysis and this deep history of the past several years was incredibly illuminating. We have a lot of questions coming in, and I'm so excited to get right to them, so I'll ask the first one. Currently, there is a growing criticism of carceral feminism, rejecting the use of criminal laws to address sexual violence. How do you view the relationship between the criminal enforcement of sexual assault law and trial by social media? Are these two routes complementary or mutually exclusive?
I would, I guess, assess at this point that I see them as complementary. That is, in the book, I talk about the ways in which social media has been exceptionally powerful in reforming law. I talk a lot about the Brock Turner case and the ways in which out of that case have come transformations across the country to statutes of limitations, have come campaigns that successfully have unseated judges, have come a lot of awareness around what types of crimes and harms should be encompassed within sexual assault. And with these changes also, I offer the concern in the book that there may not have been significant discussions about how, as we do things like extend statutes of limitations, like extend the types of crime categories that may be included in criminal laws, we may not be considering who will ultimately likely bear the impact of those laws. And so even though the expansion, and one of the cases I talk about in the book is a case called McWhorter, which comes from the 1950s in Alabama. And it's a case in which a white Southern woman reports that an African-American man has been standing outside her window, smoking a cigarette. And the court in that case talks about and sets the initial foundation for the idea of criminalizing crimes like stalking and loitering. And a case like that can provide a very challenging precedent, because on the one hand, we have very, very important movements in the women's movement to criminalize stalking, and I teach family violence, and we know that that is part and parcel often of an escalating set of behaviors that can be exceptionally dangerous and that we've not recognized before. On the other hand, a case like McWhorter kind of does stand for the proposition that we may be more likely to identify innocent behaviors, as we know now, by individuals of color as potentially criminal behaviors than we would be to identify people who are not of color doing the same thing. So I'd say they're complementary. That said, I think social media does have the power potentially to contradict and counteract some of these things too.
I thank you. I think that maybe a related question is this next question, or a slightly related, given the concerns that you've noted throughout today about Black men's convictions, in what ways can Black Lives Matter and the Me Too movement work together? And maybe that's also a question about how they work together on social media.
Yeah, so I think that I chose to end with the Ginsburg quote because too often Me Too is politically constructed or constructed in the media as a gendered movement. And rather than setting it in the context of other social movements or exploring how those social movements are related. And I think one thing that the Black Lives Matter movement, particularly within the last year, has really brought to light is the ways in which within any social movement, certain voices get amplified and certain voices are not included. And one of the ways I think that Black Lives Matter can really intersect in a very important way with Me Too is by giving a roadmap to highlighting more voices. So one thing that I've come across as I was writing the book is that Tarana Burke, who originated the Me Too statement, today when she's interviewed, she expresses discomfort with it because there's an uncertainty there as to who is really speaking through Me Too. And legitimately, pragmatically, we look and we wonder who really now is being benefited here. Is this having the widespread impact in the workplace, for example, so that people of all socioeconomic levels can exercise their rights and be able to bring cases? And we're at a real crossroads, I think, where we're still waiting to see what that impact would be. Black Lives Matter can offer a lot to the Me Too movement in thinking through a lot of these questions.
Thank you. I think, thank you. And I think this is also, I think these questions are all related to each other. Can you speak to how your research helps reveal what's at stake when discussing the historical, consistent, ongoing adamacy about women's lies, or why so many want to disbelieve women?
For me, a lot of these conversations center around power. And one of the things that I have really wanted to bring to light in not just this project, but other work that I work on is the ways in which we may have conversations that we think are talking about common sense ideas, or we may use, I mentioned tonight, I think that people will use as evidence particular things like filing a civil suit that we may just assume is common sense, that, oh, they must be out for the money, and so they can't have a dual motive. And we may not question how these ideas and stereotypes are operating in the background of the ways in which we're framing our decisions. And today, we have all of these critiques coming forward of the ways in which Facebook and other platforms are, in fact, deliberately manipulating our emotions and behavior, and the ways in which memes and ideas are disseminated in ways that even very intelligent and savvy people will not recognize them as such. And one of the things I really try to do in this work is to expose those power relationships, so that we all look back and question when we make a particular statement, where is this founded? Where is this coming from?
And just as a kind of follow-up question to that, was there anything about the platform Twitter itself and how Twitter handles disinformation or misinformation or promotes information that came up when you were kind of studying these case studies?
Yeah, so one of the things I didn't really fully address tonight that is a big topic or overarching theme in the book is what's the role of law here? And one of the ways that law is certainly being challenged is by the extent of control that social media platforms like Twitter and others are now asserting over who can say what's disseminated, what we see, what we hear, how we hear it, how many, what the word limit is. As I wrote this, the word limit on Twitter was expanded. And by just a few words, that really changes the discourse. You could write a book on that little expansion. So I would say, that an important focus is not only on what these conversations are or how these conversations are impacting law, but how the people that control the conversations are impacting law. And I discuss a lot in the book the ways in which a lot of the positive changes that have come out of Me Too have largely been corporate changes, saying we're going to fire someone, we're going to dismiss them, zero tolerance policies, and offices of institutional equity abound in the past few years. And I offer the concern in the book that by placing corporations in charge of setting legal boundaries, and that would include a corporate environment and include a social media platform, in many ways, you've got the fox guarding the hen house. That is, law is being set by these entities who are not moral actors. These are profit-seeking entities that are ultimately accountable to shareholders or to the bottom line. When we have corporations, there's a recent law that was proposed in New York, I think, that said corporations need to dismiss somebody under XYZ criteria. That may be well and good, but when we're putting those disciplinary decisions outside the hands of the institution of law, there is that danger of corruptibility there. And I do think it's a major shift, especially where so few cases do see the inside of a courtroom.
Thank you. So we're about out of time. So I have a final, do have a final question for you, but first I wanted to just read some of the compliments that are coming in. And so just thank you for your deep intersectional analysis. Thank you for this embedded research. Thank you for the perspectives that you've lended today and in your book. So I wanted to make sure to communicate that to you before the end of the event. But then I think the final question today is, where is your research going now? The world is changing quickly. And I think that was very apparent even when you were writing the book and over the course of the book as I read it. So what's next?
I am still fascinated by law in everyday life in all of its manifestations. That is definitely still my focus. I'm very interested in the book in the ways in which we are reckoning with the place we are in terms of both what has been brought to light and continues to be brought to light by Me Too and with the Black Lives Matter movement. And as I'm thinking, I'm really thinking through our place in both being accountable for creating that more just future that I mentioned going forward. And so my next work really is going to focus on how we're processing that idea of accountability, and how we move from something I identify really as, there's a lot of finger pointing at individuals that takes place in these conversations. And there's really not enough focus on structure. So my work, I hope to move from, I don't know how, but trying to get people to move from that individual perspective to looking more at that holistic structure perspective.
And that seems like an absolutely fabulous note to end on. Going from the past or the current past or the current, right, to think about a just future. So thank you. And that was also, I think, a sign. So I just want to say, thank you for joining us. Thanks everyone for joining us in kind of celebration of Crowdsourcing the Law. I want to send in a special thank you to our co-sponsors for this event, which was the ASU Faculty Women's Association. I think a couple of you are in the audience. Thank you for being here. Thank you for co-sponsoring. And then I hope that you'll consider joining us for our next virtual event on October 28th. The scholarly series on hope and empowerment will host a presentation and conversation with Leanne Simpson, who will be talking about her book, As We Have Always Done. And again, that's on October 28th. The event will be moderated by ASU's own Jerome Clark, and we'd love for you to join us. So thank you again to our ground control team, to Dr. Cavender, to Dr. Banner. I hope that we kind of continue to think about just futures together.
Thank you.